So I see we are all set. So greetings, colleagues, to all of those watching, to the team in Athens and those in Athens and those all over who have joined us in this third installment of the Athens Public International Law Discussion Group. We're quite excited this evening. No, we will not be discussing Ukraine. I think that will probably come next time, but we are going to have a discussion on an issue which, of course, on which there has been a very recent judgment by the International Court of Justice in the Congo-Uganda reparations case. Now, every discussion group, as you know, has, a small history behind it. So let me just briefly say that this, our speaker this evening is Dr. Martins Paparinskis. And the whole idea of his intervention with us came from a very interesting article that he recently published in the Modern Law Review, a case against crippling compensation in the international law of state responsibility. So from there, where he makes a case whether this principle of full reparation, as we know it in the law of state responsibility, should actually be there. And so let me just introduce Martins. He slightly adjusted his topic because a few days ago we had the judgment on the reparation of the arms activities on the territory of the Congo. That also allowed us, and I want to thank him very much, to have as a very eminent discussant for this evening, Professor Pierre d'Argent, and I will also introduce him briefly. So Dr. Martins Paparinskis is a reader in public international law at the University College London, and he has published widely, both on foundational and specialist topics of public international law, in numerous reviews and journals, such as the American Journal, the British Yearbook, the European Journal of International Law, the Modern Law Review, and others. Martins is a member of the Permanent Court of Arbitration, the OSCE Court of Conciliation and Arbitration, and the ICSID Panels. And he was recently elected, I think that we should congratulate him, was recently elected to the International Law Commission for the 2023-2027 quinquennium. As I said, and we put it also in the invitation for those of our students who are following and our younger colleagues, I suggest you look, I hope you have looked over his recent publication on this issue. And then to discuss what Martin might be proposing or suggesting is my distinguished colleague, Professor Pierre d'Argent from the University of Louvain. Professor d'Argent is member of the Institut de Droit International. He's the president of the European Society of International Law, member of the Brussels Bar, and special counsel to Foley Hoag. Notably, Pierre d'Argent was counsel and advocate of Uganda in the DRC versus Uganda case. So a warm welcome to both. Thank you for accepting this invitation. I will turn over the floor to Dr. Paparinskis, who will speak for around 30 minutes maximum, I think. And then I will hand the floor over to Professor Pierre d'Argent for his reaction, and we can open to a Q&A session. Please, colleagues and students, don't be afraid to raise your hand or put questions in the chat box. This is what discussion groups are for. So Martins, over to you and welcome.
Well, many thanks, Professor Pazartzis, dear Faye, if I may, for the wonderfully kind words of introduction and for the invitation. I cannot really begin by not mentioning how thrilled I am to be presenting in Athens, even if only virtually. Always had an incredibly soft spot for the Greek School of International Law, many inspiring figures, colleagues and contemporaries of whom some I see on screen, as well as students. So it's fantastic to be part of the stellar discussion group series so early on as well. I think that this is certainly something that all international lawyers are increasingly tuning in on Wednesday evenings. So To dive straight in, what I want to talk to you about today is the question of crippling compensation and where we stand in that topic after the judgment of the International Court of Justice of 9th February in the armed activities on the territory of the Congo case that I will refer by shorthand as armed activities. So this will be an unabashedly lawyerly talk, law as law, formalist, positivist legal arguments. But I thought that it perhaps might be worth noting that the focus on the legal issues does not, of course, mean that one is insensitive to the broader implications and policy issues raised for the quite possibly survival and suffering of individuals and groups and political communities. I think particularly in these days, sensitivity to formalism need not be divorced from appreciation of the broader policy issues. So with that point having been made, let me suggest that I will make 3 points. The first 2 I will try to make relatively briefly, and I hope that I'm not excessively presumptuous if I think that some of those who have tuned in might be aware of the general gist of my argument that I'll be presenting. The first point will introduce the concept of crippling compensation and the query. And this is to quote from the court's judgment in armed activities, paragraph 407, a short paragraph to which I'll be returning continuously throughout the talk. Is the question whether, and I quote, in determining the amount of compensation, account should be taken of the financial burden imposed on the responsible state, given its economic condition, end of quote. I will introduce the concept, and I will suggest that the mainstream answer reflected in the 2001 International Law Commission's articles on state responsibility for internationally wrongful acts, that I will refer to as the 2001 articles, is no. It should not be taken into account. In the second part, I will consider the possible critique of that position, and in particular that the intellectual assumptions that guided the International Law Commission adopting this position in the late 1990s have been falsified by subsequent developments in the international legal order. And in the third part, I hope the most substantial one, I will look at the treatment of the issue in recent state and judicial practice with a particular eye to the armed activities judgment. And I think that my main claim is that even though the court does not engage in the issue beyond barely 4 lines, there's a surprising amount that we can take away from those barely 4 lines with a careful reading, both for the broader legal principle and as a guideline and framework for future state practice and judicial practice in the area. Right, so let me move to my first point, and Faye already introduced the basic intellectual framework under which we are operating, the principle of full reparation reflected in customary law terms in the age-old judgment of the factory at Chorzów. Obviously, we all pronounce it in correct Polish terms, no Chorzów for us, and something that has been accepted as reflective of customary law by the International Law Commission as well in Article 31, and endorsed as customary by the International Court of Justice in its recent judgment. How do we implement full reparation? Well, traditionally, International Law Commission and international courts and tribunals have identified 3 forms: restitution, compensation, and satisfaction. The first and third of those come with explicit limitations against excessiveness. Restitution, says Article 35 of the 2001 articles, cannot be impossible or disproportionate. Satisfaction, says Article 37, cannot be humiliating or disproportionate. On compensation, a contrario, we do not have a limitation against disproportionality. Is that something that the International Law Commission overlooked? No, it seems not. Commentary 5 to Article 34 tells us that disproportionality regarding compensation is reflected in the causal link. So it is not something that is reflected in the amount. Why did the International Law Commission adopt that position? Here, as on many points, we have to look at the discussions within the International Law Commission, the work of special rapporteurs, and the reactions in the Sixth Committee. And we are fortunate, as on many issues, that the brightest mind on these issues, the late and much missed Judge Crawford, addressed the issue explicitly in his third report, where he dealt with where to become the second part, content of rules of responsibility. So Crawford had three explicit reasons for answering no to the question of crippling compensation, and one, I think, implicit one. The first reason is that the whole question seemed trivial to him. Crawford said, well, it's not that obvious that there are too many claims in international law that raise significant monetary issues. And so we have to put ourselves sort of in the shoes of the late 1990s international law. And what Crawford is looking about is mostly looking at regional human rights. And he says, well, there are amounts, but compared with the full capacity of states to pay, it's usually relatively trivial. So it's mostly trivial. When it is not trivial, we can rely on that great principle that people should not be silly. So this is a reading of history for Crawford and the International Law Commission. What is the takeaway from war reparations? For Crawford, it is that if you do Versailles, you get Hitler. If you are magnanimous after the Second World War, you get the United Nations. So the point is, it's not really about the rules. It's about not being silly. And Crawford says, we can trust states to be magnanimous and appreciate that even if you have rights, you don't need to push them to the max. Also, says Crawford, there's the wisdom of the broader political community, particularly within the United Nations setting. And there he is looking at the United Nations Compensation Commission, where Security Council is balancing and rebalancing the amount of compensation that can be requested from Iraq. So very appropriately, I think yesterday, Security Council formally terminated the functioning of the United Nations Compensation Commission after the last payment by Iraq in January. So probably ground for reasonable disagreement whether the Security Council drew the line in the right place. But sort of the takeaway for Crawford is that if there are issues, we can trust the international community to take care of it. So those are things that were out there explicitly. And I think one point that was implicit, so this is not a hill that I really want to majorly die on, but there seems to be a sort of a systemic assumption. The skepticism about crippling compensation goes together with the skepticism about valuation methods and other ways through which large compensation amounts can be reached. So if we look a bit further in the report and the International Law Commission's work, Crawford is equally skeptical about compound interest and what he describes as speculative attitude to valuation like discount cash flow. So in a way, you could sort of say, well, there's a sort of a bit of an implicit assumption that we don't have a special principle for diminishing amount because we are skeptical about principles that would increase the amount. So that is the intellectual assumption. So that is where the International Law Commission arrived, broadly in line with submissions by states, I guess mostly coming from the Western European and other groups, UK, France, United States, Australia, Israel, as well as Japan. So that is what I would describe the mainstream view. So what is it that we make of it? Is that a good legal argument or not? So I just have here a slim volume looking at all these matters by Pierre, La Réparation de Guerre under 9, Médicinal Public, published, I think, just after the International Law Commission concluded on these matters, where he spends 10 pages looking at it. And when I'm looking at what Pierre said in page 742, he arrived at a rather qualified conclusion, saying that one couldn't really argue that there was a limit at the level of the content of the rules of reparation. At the same time, sort of people who were toying with the Versailles type things might be raising concerns about abusive invocation of rights, so possibly something that is properly dealt with, not at the level of, intellectually speaking, part 2, but rather part 3. So I would put it as, I suppose, a qualified skepticism that possibly ILC was right in law, but it may have slightly exaggerated the triviality of the issue and the way how it was addressed elsewhere. So what were the other reactions? And otherwise, I think that the state practice was just as one might expect in the decentralized setting of public international law, mixed. Investment arbitration was interesting mostly because it did not raise challenges of against the claims. So then that strikes me as a very legally significant silence. There have been quite a few cases which raise this assumption. So if we look at the state practice, how do Crawford's, how do ILC's assumptions fare? So recall the 3 explicit assumptions that the challenge is trivial. If it is not trivial, we can trust individual actors or the bigger system. And in any event, the principles that might generate large sums have been also minimized. And I think that none of them has aged well. So we have claims. We have claims, particularly in investment arbitration, but we also have fairly significant claims in interstate setting. The Eritrea-Ethiopia Claims Commission is something that I will return to a few times. And of course, Democratic Republic of Congo had, even though the award was a significantly smaller one, the claim itself was to the amount of $12 billion. So claims are made, and I think probably an additional point that might not have been fully appreciated in the 1990s is the role of non-state actors and the fact that non-state actors, unlike states, are not repeat players. So they are not really open to the type of system-preserving arguments. They are not going to be there for centuries. So there is a less of an interest in them to see that claims and their implementation is sustainable. So for investment arbitration and for human rights claims, that systemic logic doesn't really work. And the political wisdom that was there for the United Nations Compensation Commission hasn't really manifested itself too strongly subsequently. So Ethiopia Eritrea Claims Commission went to the merits to the reparation stage, as did the armed activities case. And in investment arbitration, the procedural structure is such that it is not a straightforward proposition to implement any of these concerns. Also, the aspects that the International Law Commission thought would minimize the likelihood of large claims like compound interest and discount cash flow valuation have been largely rejected, particularly in investment arbitration practice, indeed including in tribunals chaired by Judge Crawford. So we cannot really say that this is just, investment arbitrators not understanding PIL. And compound interest has had its, I think it has been broadly endorsed, at least in the law of the sea, interstate dispute settlement. So you could sort of say, well, the intellectual assumptions have shifted. Now, of course, the fact that a proposition may not be as good as it was cracked up to be when it was formulated is only one part of the argument. What we are really interested as public international lawyers is whether it has been endorsed and accepted by state and judicial practice. Now, on the judicial practice side, we have the very interesting single example of criticism in the Ethiopia-Eritrea Claims Commission, where Crawford, the world being a small place, was one of the leading counsel for Eritrea on the matter. And in that case, the Claims Commission was critical of the very large claims that both parties made, and it considered in principle the possibility of capping the damages awarded by reference to the capacity to pay. And that is where the phrase that I quoted in the very beginning, whether in determining the amount of compensation account should be taken or the financial burden imposed on a responsible state given its economic condition, comes. It ultimately did not reach that conclusion, but that was, at the point of principle, I think really a significant pushback, perhaps the most significant pushback by a judicial body against anything that the International Law Commission had said. So what do we sort of take away from that? And when I wrote my paper in 2020, my conclusion was that mostly, warts and all, the mainstream position was endorsed by the state and judicial practice. There was the deafening silence of states in responding to the multi-billion claims, where, if there ever was a context, procedural and substantive, where that would focus the mind, it is probably a sad situation. And if states are not raising a legal argument in that setting, that seems like a significant, I suppose, opinion non-juris proposition that it would be too trivial an argument to raise. Eritrea-Ethiopia Claims Commission was, I thought, an interesting example. Again, Pierre wrote an interesting comment on this case in the Annuaire Français de Droit International, sort of pointing to some of the legal and, I suppose, moral philosophical problems there. But ultimately, by the cruel black letter argument, we are interested of whether anybody after that referred to it. Sort of what was the endorsement of state practice? And there I could really see very little of that. So ultimately, I concluded that even though the argument of International Law Commission was problematic, it was still broadly endorsed in state practice. So that was just to summarize what I have said so far. The mainstream position says that the effect of compensation is irrelevant, and it was broadly endorsed in the next 15-ish, 20-ish year of state practice, mostly by silence in refuting allegations that could possibly be crippling. There have been a number of interesting developments just in the last few years, and let me note three of them briefly and then spend more time. I think I have probably about 10 minutes or so remaining on the armed activities case. And I think I'll just to say that there is no, as perhaps not surprisingly in the decentralized international legal order, there will no clear punchline, and I think I'll try to be rather, I suppose, honest and transparent in identifying the gaps in the argument. The first is the dissenting opinion by Judge Kateka in the Dusget integrity case in late 2019. Judge Kateka, of course, was also a member of the International Law Commission at the time when the articles were debated. And as part of his dissenting opinion on reparations, he notes in paragraphs 25 and 26 that it's possible that, despite the neutral formulation, that the concerns about crippling compensation could still, to some extent, be addressed through the International Law Commission's articles. I think it's interesting to know that this was just to, I suppose, to draw attention to the problematic of capacity that the respondent in this case was São Tomé and Príncipe, and the ultimate award was for less than $15 million. So we are not talking merely about the multi-billion claims that there may be polities for whom even comparatively smaller sums are capacity existential issues raising. Indeed, because the respondent state had not received assistance from the PCA Trust Fund, it had not even been able to participate in reparations. So here we have a note in this ending opinion, so as it were, certainly not a majority view, but mentioned by one participant as a debate as a legally relevant consideration. The second example comes from investment law. In the ancestral reform process of investment law that is taking place in Working Group 3, the ancestral secretariat last August prepared a draft paper on compensation and damages, inviting comments by states. And one of the points among many that it invited comments on was crippling compensation. A few states answered, and none of them reacted to the particular point. But to be fair, I think that there were five states that answered, so perhaps one cannot infer anything too much on that one way or the other. And probably the most thorough engagement from the United States State Department was really mostly directed at the idea that these are issues that are not dealt, that are properly better dealt elsewhere. So 2 points of which we cannot really get too much out of. The third is a judicial case that was decided last November and was published last December of the Inter-American Court of Human Rights, the Caso Profesores de Chanarali Otras Municipalidades versus Chile. Just to briefly, I suppose, I don't imagine that too many of you would know of this case. So this was a case relating to teacher salaries, very briefly introducing the issue under the legal regime dating back to the times of Pinochet, educational salary reform promised to teachers that had ultimately, even though it had been required by domestic law and domestic judgments, not been implemented. And this was something that was raised by a large group of claimants before the Inter-American Court of Human Rights. Chile suggested to the court the importance of commissioning an expert report on the possible crippling compensation. And the Inter-American Court asked me to write an opinion on the matter. And so this was solely on the question of reparations, so nothing at all on the substantive issue. Ultimately, the Chilean government invoked the argument of crippling compensation twice, as it is recounted in the judgment, first in relation to restitution. And on that point, the court rejected it. It said that it is incompatible with the basic idea of state responsibility. And secondly, Chile invoked it in paragraph 226 of the judgment in relation to compensation, sort of making the point that it is potentially a very significant sum comparable to the educational budget and other significant public goods of the country. On this point, the court didn't say anything at all. It just proceeded to the calculation of a compensation, which ultimately appeared to be significantly below the amount that could have been considered to be crippling. So the takeaway, I suppose, here is that this is an argument that has been raised explicitly by a state and that has not been rejected on the point of compensation by an international court. And just to add that Chile is interesting because Chile was one of the very few states that in the 1990s objected to crippling compensation in the Sixth Committee. So it is not an opportunistic point. Chile has a consistent argument going on. All right. So those are the three, as it were, points that were there floating out before the armed activities case. What is it that we can take away from armed activities? Well, let me just read everything that the court said. It's not too much, and then I would just suggest a number of points that we can take away from this in the 5 minutes remaining. The paragraph 407 of the judgment was the following, and just as a backdrop, it's the authentic language is French. I will read it in English. I don't think that in the relevant respect it is different. The court is satisfied that the total sum awarded and the terms of payment remain within the capacity of Uganda to pay. Therefore, the court does not need to consider the question whether, in determining the amount of compensation, account should be taken of the financial burden imposed on the responsible state, given its economic condition. So, what is, as it were, the authority of this proposition? This is something that reflects the arguments raised by Uganda in its written pleadings, referring to the Eritrea-Ethiopia Claims Commission practice, and it's in its oral pleadings where the issue was raised by the agent for Uganda, as well as counsel Alain Pelé on behalf of Uganda. So the court leaves the issue open. The only judge who addressed it explicitly, as far as I can see, is Judge Hoag, the judge appointed by Democratic Republic of Congo, who says in paragraph 32 of his opinion, he refers to, and I quote, la position de l'Ouganda qui a tort prétend que le principe pertinent de droit international interdit d'exiger un versement excédant les capacités de paiement des débiteurs, alors qu'il n'existe pas véritablement de règles de droit international en la matière. So Uganda errs in suggesting that a rule of international law prohibits it, even though there doesn't exist a rule of international law on the issue. I mean, I may be overreading it because I have been thinking about it for such a long time, but that seems a slightly softer formulation than a possible expression that a rule of international law positively permits that compensation. I think that Dode seems to be very, very careful of saying that no rule exists on the matter. And overall, I suppose if we think about the framing, sort of what is a general vibe from the court, the greatest anti-crippling compensation authority, Eritrea-Ethiopia Claims Commission, has a very good run throughout, but equally the 2001 International Law Commission's article also have a very, very good run. So I think it's sort of broadly, this is neutral. The court does leave the issues open. But what is it exactly that is left open? So I think that is interesting, because by leaving open the ultimate conclusion, some things are left in. And I think that it is interesting that I think that there are three important points that we do get from here. The first two fall together, and the first is that capacity of the state to pay is a legally justiciable concept. That is the first point. And the second point, that this is something that is incidentally capable of determination in formalized dispute settlement. Now, very appropriately presenting in virtual Athens, this of course calls to mind the great Sokobel case, where the issue of Greece's capacity to pay was one of the legal issues. Somewhat oddly argued, and the court said in the end that this was not something that parties had submitted to it, but people writing separate opinions were a bit less certain. Judge Singa, for example, thought that experts could be appointed, and Judge Hudson thought that Greece simply had failed to provide factual evidence. But also, interestingly, in light of the judgment, it referred to Belgium's promise that it wouldn't be asking for the full sum immediately. Now, that is, something that I will return to in a bit. So the third point is most important, and that the court says that it has determined that the payment is within Uganda's capacity of the pay. And there are two important points here. One is that it appears that the court necessarily assumes that a judicial body in international law, or possibly the International Court of Justice, has an inherent power to order payment in installments. That strikes me as an important proposition, and I think if that is something that, if I had put it in an exam question on 8th of February, and a student had given that answer, I would not necessarily have given them a distinction grade. So that strikes me as an interesting proposition that is worth reflecting upon. There's an international dispute settlement angle. There's also the law of state responsibility angle. Is there practice of ordering and awarding compensation installments? Again, if we go to Crawford's third report, he refers to some practice. So Australia promised Nauru in the phosphates of Nauru case payment in installments. The Velasquez-Rodriguez was awarded in monthly installments, but ultimately it doesn't seem that there's a rule at that level. Judge Tomka, in paragraph 10 of his declaration, addresses payment in installments in relation to compensation, how to calculate compensation. He says, in the last paragraph, while the DRC and Uganda would have been free to agree on the conditions for a possible payment of the compensation installments, the court's decision without protecting the value of the compensation awarded is not, in my view, fair to the applicant. So still something that I think Judge Tomka is saying, that this is one aspect of implementing the principle of full reparation. So perhaps the takeaway is that one could have been excessively formalist in thinking about the forms and implementation of the forms. I think that Judge Salah, in his opinion, has the more general concern about the excessive formalism in this context. There are legal and policy questions, and I think there Pierre's comment in the Annuaire Française de Droit International is very interesting on the point, because he points that if we look back at Versailles, the idea of pushing things in annual installment in perpetuity has its own policy concern. So there are issues there. So I'm winding down with really the last 1.5 minutes here. Where does the number come from? Really being rather boring. We are talking about the principles, but here the court in paragraph 406 awards the sum in annual installments of 65 million in 4 years. So presumably, if full immediate reparation is the norm, the court seems to be saying 65 million in 5 years is okay. In 4 years, 81 million might perhaps be a bit much. So why is that the case? And here I'm just really outrageously reading things in. The only number that appears as an actual number in the case is a point raised by the agent of Uganda. I think it was $7.25 billion, the consolidated annual spending of Uganda. And 65 million falls rather neatly below the 1% line of that, and 81 would be above. So perhaps the court is saying that if you are going above a certain percentage, that might be raising capacity issues. So that is not what the court said. I think that is just, I suppose, possibly things that went into calculating the number and installment. But I think that the takeaway, as I said, is less, actually the two sentences tell us quite a lot. Capacity is a legal issue and capable of legal inquiry, even though the court has not answered whether crippling compensation would operate at the level of content. It appears to have influenced the shaping of the form of reparation. And I think that that is something that is important, that both the Inter-American Court and the International Court have considered the issue but left the point open. We have state practice by multiple states building towards a certain proposition, and we have something appearing towards a methodology, a certain amount against which one could argue about annual installments at the very least, to the extent that so that it wouldn't overwhelm states' capacity in the particular year. And that is what I wanted to say. Many thanks again.
Thank you very much, Martins, for this extremely interesting presentation. I was taking notes, and I was also thinking while you were talking about Pierre d'Argent's a short book on the War of Reparations, and in one of those 700, somewhere in around page 700, I think, I remember him asking whether the idea itself of full reparation is a fiction. I remember it had sort of, and then he goes on to analyze, whether, restitution is ever possible, really, and then what compensation can do. So, but I have a lot of questions, but I will give the floor immediately to Pierre d'Argent, Professor Pierre d'Argent. I'm sure he probably has some comments.
Thanks very much, Faye. Thanks very much for your invitation, your kind words at the beginning. I'm very pleased to meet all of you. I'm very pleased and honored to be able to comment on Martin's great presentation and paper. And I remember we exchanged, Martins, when you published your papers before the hearings in the DRC Uganda case, and it really gave us food for thought as also today. Now, maybe before going to the judgment of 9 February, and very quickly, let me brush some strategies I think the courts and tribunals have basically 3 possible strategies when addressing this, when faced with this issue of crippling claims. And I'll come back to crippling claims, because as we know from all those cases, the claim might be extremely high, but the outcome is not necessarily so. So for the judge, probably those huge claims are a little bit intimidating. And what are the strategies that are available to the judge? The first strategy, I think, and Martins, you have mentioned it, is the avoidance. And how do you avoid addressing the issue? Well, you do like the court did in the DRC Uganda case. You take your instruction book from the Diallo case and you say, well, there are 3 steps: evidence, proof of the injury, causal link with the wrongful act, and then evaluation. And actually, at each state of that process, there is a judgment to be made. Is the evidence sufficient to establish the injury, the harm, the loss as claimed? Is there a causal link with the injury? We can come back on causality in the DRC Uganda judgment and the kind of presumption of causality that the court has put in relation to Ituri. And then the evaluation. And we know in this case how the court, presumably not addressing the matter ex aequo bono because it has no power to do so. But when it came to those numbers without clear justification, tying to the specific circumstances of the case, the available evidence, and there is this sentence that come back several times in the judgment to explain the overall figure, which helps the court to avoid certain thorny issues. How much is the life of a Congolese person worth? $5,000, $10,000? How many have been killed? We don't know. How much for a rape victim? So all those questions the court has put aside with big numbers, overall numbers, where by harm to persons, harms to property, and harms to an injury to natural resources, all that is put together in a big pot, stirred, and the court comes out with a number. How does it come to that number? We don't know. But it certainly played. I mean, sometimes it says lack of evidence for this claim. Sometimes it says lack of causality for that other claim. And then evaluation is a rule of thumb. You know, it's a global evaluation. But and that leads to paragraph 407. That leads to the consideration that there is no need to address the issue of crippling compensation, because when the judicial process comes to an end, the outcome is not so crippling, and the avoidance technique has proved to be efficient. The other way to address this issue of crippling compensation is to address it forcefully, radically. And that is, I think, the question that came in the Ethiopia-Eritrea Claims Commission, on which I commented in the Annuaire Français, is this idea to take the obligation not to deprive a people of its means of subsistence. It is correct to say, and Martins, you rightly recall, that the ILC draft articles say nothing about it, or at least that the rules as they stand do not provide any guidance to take that into account. It's a substantive human rights obligation. The point I was making in the Annuaire Français commentary of the Ethiopia-Eritrea Claims Commission is that maybe it is a duty of the arbitrator, of the judge, in the sense that the power conferred by the state, if the two litigant states are bound by the same obligation not to deprive a people of its means of subsistence, surely they cannot give the power to an adjudicator to decide a case that would result in depriving a people of its means of subsistence. So it's not only a substantive obligation in interstate relations, but maybe there's an argument to be made that it is also a juridical, a limit to the power of the adjudicator.
Could it be judicial propriety? Sorry for butting in.
Whether you call it judicial propriety or whether it goes beyond the power. I mean, the judge cannot be, because jurisdiction is based on consent. I mean, if you're a state judge bound by this human rights obligation, surely you would be, as an organ of the state, bound to apply that obligation. You cannot lend your judicial power to a judgment which is attributable to your state, and to a judgment that would breach an international obligation of the state you are an organ of. Okay, so I think that is, I would argue a case before a domestic court. I would certainly make that case, and I would say, listen, you are going to make it will result in a human rights violation, and as a judge you must respect human rights. Now, if you take that idea to the international scene, and you can say, well, is the international judge bound by human rights instrument, etc.? No, the question is, who is giving power to the judge? And on the international plane, the power results from consent. And we, I think, could make an argument that states cannot consent because they are bound by certain obligations. They cannot consent. You cannot conceive that they give the power to an adjudicator, and that the adjudicator uses that power to do something that the states themselves may not do. Okay, so it's a fairly, maybe it's a little bit bizarre argument, but at the end of the day, if it's based, but of course it would be for the judge to reason that way and to consider its power, etc. But could it not also
be? Sorry, it would be a judicial restraint on the part of the judge.
It would be a judicial restraint. It would be the judge saying it, but the judge can tie back that restraint to the power it received from the parties. And then you will come to, are both states parties to the covenant, and is this rule binding on blah, 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 blah. But in a way, how would we transpose that? Because I think in domestic law, it may arise also. How do we transpose that internationally? I'm just suggesting that it could be a way to radically address the issue. I would say institutionally address the issue, to take the substantive obligation and turn the substantive obligation into an institutional limit to the power of the judge. And then there is the third, I think, way to address crippling compensation, not only avoiding the issue, not only, and maybe if you don't want to radically, I mean, the paragraph 407 is probably the court wants to avoid crippling compensation, but wants to avoid addressing crippling compensation, okay? So wants to avoid to address that last bit, that other technique of avoidance, the radical avoidance technique in terms of institution. And the last way is pragmatically, it's the issue of the capacity to pay. Now, Martin's raised this very important and interesting question. Does an international arbitrator have the power to split the payment and order installments? To that question, I never thought about that question. It's a great question. My first immediate answer to that would be, yes, it's in the inherent power of the judge if the judge has the power to settle the dispute. The judge has the power to decide the case and to settle the dispute. I think the court in this case was already very much concerned by the fact that it took so many years, okay, after the judgment on the merits. The DRC came back 10 years later, and then it took between 2015 and 2022 for the case to be decided. It was time to put an end to it, to the dispute. And I think the court serves its statutory purpose when it takes a decision that is pragmatic and capable of being applied by the states concerned. And surely the court would hate to face a situation where no payment would come. Look also what the court decided on the installment. It did not say to Uganda, pay $65 million on the 1st of March. It said paid by September. And that's also pragmatic. Why September? But well, it gives Uganda a bit of time to address the matter, and to the same extent, has the court the power to make installment? Has the court to decide that the installment start on this day or that day? I would say yes, again, because it's the inherent power of the adjudicator to settle the dispute, or at least to exercise its power in such a way, in such a clever way, that most likely this decision, this judgment, is not going to fuel between the parties a new dispute. Now, the two parties may decide, for another sum of money. And maybe, maybe Uganda can say, well, you are entitled to 325 million over 5 years. You know what? I give you a check of 200 million now. Take it or leave it. Okay. That is, I don't think this is a matter being discussed between the parties, but what would be wrong about it? It's a sum of money. It's a judgment of the court. The judgment is, of course, binding, but to the same extent that a border that is decided by the court can be changed by agreement by the parties, as long as we are not changing, as long as we are not agreeing to depart from peremptory norms, that's not a problem. And maybe the DRC could find it more agreeable to receive money now rather than to have to wait for 5 years. But I would argue that the basic issue in this pragmatic approach of ordering installments it's the issue of time. Of course, installment is related to the passage of time, and the issue of crippling compensation is very much linked to the capacity. It's the issue of the capacity to pay, and the capacity to pay has to be assessed at a certain moment in time. And as Faye, you know my argument about that. The international law somehow, because it is built on the idea that states, as opposed to individuals, are eternal, we die, and when we die, there is a succession. And all children may refuse the succession if we, if the bank account is negative, you have a clean slate. And for states are supposedly eternal, or this is at least how they like to see themselves. So if the amount of time is eternity, by definition and mathematically, any state on the planet, even the poorer of all states, has an unlimited capacity to pay if the time frame is eternity. Because if the time frame is eternity, and if you pay $1 a day, at the end of eternity, it will be an enormous amount of money. But we know this is not the reality. So necessarily, crippling compensation is an issue that deals with time. War reparations also deal with time. And it's a social matter. Why would the future generations have to bear the burden? We're talking a lot about our duties vis-a-vis the future generations, global climate change, etc., etc. But it's really the only, and that's what is the issue. How far? How many generations? 1, 2, 3, 4, 5? It's just, and also it depends on where the debt comes from. And very often those crippling compensation claims come from very traumatic events in the history of the states concerned. So inevitably, time, which will kill us individuals, time comes in the picture. And there's no way to think about the capacity to pay without having a certain amount of time in mind, over 20 years, 25 years. There's no rule of international law in that regard, absolutely no rule. And on paper, you may remember that the Versailles installments were to be paid until 1988. Can you imagine that? 88, or was it 88 or 86? I don't remember. Anyway, when you look at European history between those two dates, 1919 or 1921 and 1988, it's crazy. So by definition, there will be a moment of a political decision that will put common sense back into place. So those are, and talking about the capacity to pay, because Martin's, you referred to Daudet opinion. It's interesting, after the passage you read, Daudet said, oh, well, there's no rule about the capacity to pay. And what about the capacity of the DRC to take the loss? It's a fair point. And that's why reparation, is supposed to wipe out, etc., and to reestablish the situation which in all likelihood would have existed, which is a fiction, of course, because
fiction, exactly.
It's a time machine. We have to go back in time, see the 1 second before the wrongful act, and then invent a future that has never existed and up to today. So so those were my general remarks. I have I took a few notes. If I still have 2 minutes, Faye. Yes, I think coming back to the issue of claims, And as I said, claims can be very high and the outcome very low. In the DRC Uganda setting, the negotiation started with a claim of 23.5. And then it was reduced to 13.5 when the case was resumed before the court. And at the end of the oral pleadings, the DRC was only claiming 11.5. One of the reasons for this change is that, can you imagine how the case was presented? In the DRC claim, there was a huge claim for the killing of wild animals, including elephants. And in their written submissions, they claimed a certain amount of money per elephant killed, and they calculated the first and the second generation of elephants on the basis of each mother elephant having a baby every year, while the gestation for an elephant is 22 months, and a mother elephant usually waits 4 years before having another baby. So the claim defied nature. So it was simply stupid.
And even then put a question of time, Pierre.
Because
till what point of eternity?
Yeah, why two generations? Why 2 generations?
Yeah.
Well, supposedly it was because it takes the time to that the herd comes back. So that's why it went from 13.5 to 11.5. But during the first round of oral pleadings, the DRC presented its claim on elephants without any change, despite the fact that we had destroyed their claim in the counter memorial. They did not take it into account. Anyway, so we had a lot of fun that day. Anyway, it's not nice, but it's a serious matter. I mean, 2 billion. So the claim, phrasing the claim is extremely, giving credibility to the claim is important. But what I was about to say about claims, and this is not in the interstate context, but in arbitration, in investment arbitration, I've always suspected, that's a theory that I would like to see checked in reality. I've always suspected that investors or claimants are not always investors, because we have many cases decided on jurisdiction saying you were not an investor. So claimant who allege to be investors, I think in certain situations, and it might exist before domestic court also, or in commercial arbitration, I think they beef up their claim because they put their claim in their books and they go to the auditors to certify their accounts every year, PwC, etc., all the great firms that are checking the accounts of corporations. When you put a litigious debt in your book, it's an asset, financially speaking. I mean, not financially speaking, but from an accountancy point of view, it is an asset. You have a claim, and you have to convince the accountant that this amount of money is relates to a credible claim. Otherwise, you cannot put it in your books. The purpose of putting a debt in your book, a litigious claim in your book, is to say to your shareholders, to your banker, I am financially sound. I have a 2 billion claim. And what do you do with that? You go to your bank and you request. You simply request cash. And you say, look, give me cash today. I'm going to repay you in a few years. And look, I have a huge claim. And when I will receive money, this is not the issue of third-party funding. Third-party funding are those who are betting, investing their own money in financing the case. But this is how the corporations are using accountancy rules and using the system that allows for huge claims to be presented. And you beef up your claim, you make it credible, you hire the best lawyers, you appoint great arbitrators, etc., etc. And during all that time, you go to your bank and you say, please give me the cash. Because this is finance. Finance is about convincing a banker that you can receive money today and you will be able to pay it back because you have credible assets that will come true in the future. I think this is not an issue for international law lawyers. It is for the accountancy lawyers. How boring. But maybe the solution to all problems is, and again, this is something that I thought about because of several cases. I've argued a case before French courts and Luxembourg courts for Ukraine, poor Ukraine. But and it was really about, you know, a Luxembourg company buying debts of states in the form of arbitral awards and putting that arbitral award in the book. And the company had no asset except litigious debts. And as such, you know, when you go to your car, the garage to fix your car, every corporation does that. You know, you have invoices on your clients. You have to pay your staff. What do you do before the end of the month? Before the invoices are paid by the clients, you go to the bank and you say to the bank, give me cash today. Look at all the invoices, and eventually you can become the one entitled to claim the invoice. So this is a purely financial, everyday stuff. But I think in the investment context, it would be worth checking how the rules are played with, instrumentalized for the sole purpose of raising money. So that's what I had to say, and we can come back on the DRC Uganda judgment, of course, because there are many interesting bits in that judgment to be commented on. Thanks very much.
Thank you so much. I will ask my colleagues, perhaps Nick can convey the messages, the questions on chat box. I want to say two things in reaction to what both of you have said, especially on the issue of the famous or infamous paragraph 407. I had the impression, I mean, you could read it as not avoidance, Martins, but as pragmatic, like Pierre suggests. I'm thinking of the way sometimes the court, for example, uses elements in maritime delimitations. Okay, you start with a medium line, you take into consideration other aspects, then you reach a final line, and all this within, not exequo, okay, within the powers of the judge. I had the feeling as I'm reading the judgment that it must have crossed the minds of judges, the back of their minds, but perhaps they did not want to, like Pierre suggests, address it forcefully. But I had the impression, or maybe when you see the way the amounts come, that, you know, it was taken into consideration, Martins, perhaps also, you know, the huge sums. But maybe not, they didn't want, the court might have not wanted to take the bull by the horn.
If I may on that, Faye,
yeah.
Briefly interrupt you. Of course, in terms of argumentation in the written submissions, I mean, Martin said, Alain Pellet addressed that. In the written submissions, the way we started the counter memorial is precisely to put things into context in that regard, because the claim was so huge. So at least from a rhetorical point of view, it's a point. It's you know, you have a lot in history to draw from, and to distill in the minds of the judges that their responsibility on that issue exists, and that their judgment might have very dire consequences. But that's a purely, you know, that's a purely lawyerly argumentative point.
Absolutely. One second point I wanted to make on what both of you said is that you were discussing the inherent powers of the the court, and Martin was suggesting whether all of this. And I just wanted also to flag the attention to paragraph 404, where the court says, look, I mean, about the installments, you know, it said installments, and then it said, but don't expect me to come back and supervise what you're doing. I mean, my job ends in awarding reparation, whatever it is. One can perhaps regret that it didn't award other forms of reparation other than compensation, or didn't talk about them as much, because this was human rights issues. But, you know, my role is not that of a supervisory organ, so it didn't really exceed. I mean, the issue of installments, I think, lies within the inherent powers of the court. And my final comment before I give this floor is that we should also know that, I mean, this is the first time that this court is really dealing with massive human rights violation case. I mean, even in Colombia, Nicaragua, it was environment. And there you saw the court having this difficulty, which was mentioned by Judge Seema, I think, in a separate opinion of, you know, how do you do it if you don't have scientific evidence, and is a court competent to do it? But we've just had, I think, 3 cases or so on reparations by the court. So one can imagine that, you know, there's a lot of perhaps work or other cases to be done before it develops its own ways in dealing with issues of reparations. So I will not take the floor anymore. Nicole, I see things on the chat. I can't read everything. Will you help me, please? There's a lot of comments, and I think, I don't know if there are any raised hands. I have the impression that my friend Luis Rivera Montoyo perhaps wanted to take the floor, but I'll leave it to him. What? Hello, Luis. Yeah.
Hi, Faye.
Hi.
Well, thank you to Martins and Professor Dargent for, you know, a very interesting talk. So I won't ask Martins because we have discussed this at length here at UCL, but hearing Professor Dargent, I guess I was left wondering not what would be the exceptional case in which compensation would be crippling, but perhaps the opposite. What compensation wouldn't be crippling if you think that perhaps the worst human rights violators are those states that are the poorest. And so if the argument is that a state should be able to continue to comply with its human rights obligations, and a state is heavily indebted already, then even a compensation of $1 would be crippling for that state, because it would have to arguably go and find the money somewhere. And so, of course, I am taking that argument too far, and I know that's not what you were arguing. But from a policy perspective, I was wondering whether we are making an argument here, and we are like providing the wrong incentives to states, human rights wise at least. And I know that this argument might be very different in the investor state arbitration context. And lastly, and perhaps I would ask this to Martins, more on a practical perspective. Would a court have jurisdiction to determine whether compensation would be crippling? Would a court have, in a given case, jurisdiction to ascertain of all the variables that are involved in determining whether a state has the capacity to pay a certain amount of money? Thank you.
Thanks, Luis. Maybe we can take some more questions before I hand over the floor to the speakers. So, Nicola, can you help me? I think we have a question, a long one, from Armand Savarian. Is he
If
around?
if I may interrupt, I'm sorry.
Yeah, please, because I'm losing the.
First of all, I suggest that we take questions from the people who have raised their hands. For example, Sotiris has a question.
Okay.
Sotiri, floor is yours.
Okay, thank you. Well, my question is this essentially. In my reading of the judgment, essentially the issue of crippling compensation comes into play in two things: installments and then no interest. So for the payment of installments, there is no interest in the meantime, they're fixed. So my question is this: first of all, let's, from a historical perspective, in the horse of factory case, there is a less known, paragraph about where the court alludes to the general rules of payment. Can we see that this constitutes an element of this general rules of payment? And so, to Martins, I would like, if possible, it's not a provocation, it's just you have two hats, like an expert in international investment law, and of course, a member-elect of the ILC. Do you think that this will have a bearing on investment arbitration on the one hand? And do you think these kinds of findings, or let's say, do you think that the law of payment as is actually sufficiently addressed in the Articles of State Responsibility? Or is it something that we should think about a little bit more?
Thank you, Sotiris. Shall we give the floor to Mahit?
Thank you very much. Am I audible?
Yeah, we can hear you.
Yes. So as we know that the court has asked Uganda to pay in installments. Now, to my mind, what crops up is that does this fact in itself not implicitly show that the court has placed some reliance on the notion of crippling compensation? Because otherwise, in a utopia, Uganda would have an unlimited capacity to pay upfront. So presumably, given that the court is perhaps mindful of such a limited capacity, my question really is, why do you then think that the court might be hesitant of explicitly endorsing it, especially given the fact that limited capacity, in my opinion, is not standalone. It can be intertwined with other aspects, such as a state's capacity to produce the best possible evidence, to prepare the best possible expert reports, which then takes us into the domain of valuation techniques, which the court admittedly takes into account while computing the compensation. So in a sense, I think crippling compensation as a notion then could be broadened and connected to valuation because of a state's capacity to produce evidences pertaining to harms alleged. Thank you.
Thank you, Mohit. Shall we take another question, Faye, or shall?
Yes, please take another question, and also Armand's, please.
Yes, I will. But let's finish with Nicoletta, since in the order around, and then we'll go to the written ones. Okay, and Nicoletta, you have the floor.
Hello, and thank you for the interesting talk. Well, while I was reading the case concerning the armed activities of the territory on Congo, I ran into other reports, and there was an expert report on reparations on 2022. And he claimed that, the state should apply an evidentiary discount factor of 25%. And I was not able to understand why. What was the reason that he suggested that percent of discount? And what exactly is an evidentiary discount factor? Is there a relationship with the crippling compensation? Thank you.
Thank you, Nicoletta. I guess we can invite some reactions from the speakers, and then we can go to the second round, the written ones.
Okay. Martin?
Right. may I? And I think if I could just, I mean, really wonderful questions and I think wonderful reactions. If I could also pull in some of the things that from what Faye and Pierre said. So I suppose I think that there are probably some, I suppose, the implicit structural assumptions, but I think it might be worth spelling them out. So of course, international dispute settlement is by its form and its consensual underpinnings geared towards producing results for particular parties. But equally, particularly in the public forum, particularly at the primary judicial organ of the United Nations, it also throws a very strong shadow in other settings of the international legal argument, both in other settings of international dispute settlement, as well as, you know, the trivial point that a very small percentage of disputes are settled publicly and formally. It means that there are hundreds of disputes, possibly dormant, possibly wrong running in different settings, where people are looking at the judgment and saying, so how does that influence, does it strengthen my claim? What does that tell us? So I think that is why I think I would be interested really in pushing a bit, even kind of against the point that, you know, we are all people of the real world. We know how it happens in courts. There are things that are implicit because the audience is not merely that of the two states. The audience is of the bigger community of international states settling their disputes elsewhere. I mean, troubling would be a strong word, but I think it was, on my reading, many of these issues were not directly addressed at the pleading. So we cannot even really say, look, Congo said, pay it immediately. Uganda said, we can pull off 6 years by reference to that. Therefore, by necessary implication, this was what was chosen. On my reading, again, very, very happy to be corrected. None of these issues were raised in questions by courts. None of these issues were raised in these terms, either in the written or oral pleadings, apart from the general framing of the policy issues and apart from the one indirect reference to the payment capacity via the Ugandan agents' pleadings. So I think that would probably be sort of a bit of my point. We're interested in this case, but we are interested in because it communicates to the bigger international legal process. Two more sort of the big picture things is one is that we are, of course, talking about state responsibility. And there are at least 3 institutional settings where our normative intuitions could be very different. So in human rights setting, perhaps our normative intuition would be to be more insistent on full reparation. In investment arbitration, perhaps our normative intuition would be more sympathetic to the state actor. And in the interstate setting, and I think that is what sort of the Pierre's point about what Judge Adhoc said, our normative intuitions are likely to be mixed because there are lots of primary rules and lots of various situations. But because we conceptualize secondary rules as belonging in the same juridical space, we should be able to give to some extent answers that would be equally relevant in all settings. Now, is there an inherent power to address these matters? Well, I suppose if by necessary implication, the unanimous International Court of Justice said that it has an inherent power, it surely has it. I mean, as a matter of subsidiary means for determination of rules of international law, what could be more powerful than that? So I think it's simply people who are surprised, you know, might not have paid their attention on the 8th of February. So now we are no longer surprised about it. I think still the question that I would like to push is the way how this power is exercised, even if its existence now seems to be established. What are the parameters? If this power is invoked in investor-state arbitration, if states ask tribunals to exercise it to award. So if Venezuela were to say, please do not award more than $65 million on this $7.5 billion claim, and provided that it can be paid in 300-year annual installments in line with the International Court of Justice. Is that a credible argument? What are the legal and policy things going on there? So I'm really not nitpicking it just because these things are important and people would read them. There are a number of points that I guess that Luis's point was whether there is, I guess, capacity to determine capacity. I mean, the answer must be yes. That is what paragraph 407 says. And I think that that is, even if very curtly, that must be the implicit takeaway. Sokobel, in that sense, is if it stood for the proposition that tribunals cannot implicitly determine capacity, has been overruled. The court can determine capacity. It has determined capacity. The legal question is a rather pedestrian one. How did it determine capacity, and how do we extricate principles and methodologies to determine capacity in other cases? So Thierry's asked about rules of payments and factory ad horsum. Is this really all about valuation? And I guess ultimately, I think if we think about the international legal process, there is no one magic place in time when people knew the rules and we have to try to figure out what Count Rostovsky knew in 1928. And if we knew only that, then we would know everything. What matters is the way how the international legal community reads judgment nowadays. And I think that the way how it was read in the 1990s was not by giving a great amount on sort of rules on payment. Valuation is a consideration, but probably the one that has been most superseded in arbitral practice. So the skepticism around discount cash flow, skepticism around discount interest has been overruled. I think I will probably leave your very interesting, provocative question to another day, but certainly compensation is something that the International Law Commission has looked in a number of settings after 2001, in 2011 for responsibility of international organizations, and as well as last year in discussing Professor Sturmer's report. So some things are still being debated. I think that I'm also in agreement with sort of the Mohit's point that possibly it has been implemented. I think precisely as Pierre very rightly explained, I couldn't really add anything to it, that there are multiple points in the legal argument stage where the issue comes up and must frame directly or indirectly. I mean, I guess, as I said, my perspective is perhaps less of trying to divine the particular case, but to take away the lessons for others. And if one way to be speaking to a client, I think if the client says, how is that relevant? They probably would not be terribly satisfied if the answer is, well, I don't know, but it will be somehow feed in other discussions. How it will feed in, I cannot tell you, but it might feed in. And there are lots of stages of argument. You shouldn't really bother about these things. These are only hundreds of millions, There are more things in life. And of course, exaggerating, that was not what you were suggesting, but I think it's important to try to unpack it, even if you are absolutely right with this framing. And I think that was probably it. I think that Nicoletta had an interesting argument relating to evidentiary issues, but I think that's a rather narrow point. Perhaps I'm very happy to communicate. If you could write me an email, I'll be very happy to follow up. Thank you.
Any reactions from Pierre? Can we go through some questions on chat box? But Pierre, some reactions before,
very quickly. First on installments. Sotirios, you addressed the issue. Martins also, we spoke again about installments. And let me be clear. Uganda, I mean, from the point of view of Uganda did not take the risk of talking about installments, because we knew, of course, that once you start opening that can, the judges might be tempted to say, oh, well, yes, let's put, 20 years. After all, the war was 5 years long, and the case was more than, 20 years. So why not 20 years? It's not such a long time. 20 installments, really? So we didn't open that can on purpose. And we were not mandated to do so by our client. The DRC spoke about it in its surveillance requests, post-judgment surveillance. They had that in mind, of course. Now, concerning the law of payments, very quickly, depending what you mean by that, Sotirios, it's an interesting thing. I think it addresses two questions: the question of beyond the issue of capacity to pay, but the currency of payment and the issue of interests. Now, the currency is never addressed, and even the court, because the claim was labeled in US dollars by the DRC, where actually the only currency in the DRC is the US dollar, so they expect a payment in US dollar. Uganda, of course, is trading and using the US dollar also. We know in investment arbitration, it's always the dollar, the dollar, the dollar. I think what matters from a legal perspective is that you must choose a currency that is easily accessible for the debtor. Otherwise, you increase the debt. So it must be an easily tradable currency. And that's why the dollar is always used. And so it has become an issue, a non-issue in those days. But it was not necessarily the case prior. If it is the currency of the debtor itself, then of course the debtor can kill the debt by producing paper money and accepting devaluation of its own currency and paying the nominal amount in a currency that is worth nothing. So anyway, the second point on the law of payment is interests. Now, in the judgment, and this is one of the points I wanted to draw your attention to, I think the judgment is very good on the issue of interests and makes the difference between intérêt compensatoire, intérêt moratoire, pre-judgment interest, post-judgment interest. It's a real lesson. I mean, few people understand what interests are about, but because the duty of the judge is to set on the day of the judgment to decide on the evaluation of the injury, it depends on the available evidence. If the car was bought in 2010 and that you have a car accident in 2020, if you evaluate today, you don't need to have the pre-judgment interests are interests that are there to reach full compensation, to upgrade, to update the value of a good up to the point of the day of the judgment, because reparation is to make today the situation that would have existed. The court says, because I'm giving flat amounts, I've taken into account, which somehow means all those evaluation is done in the value of today. I've taken into account the devaluation of any evaluation I could have made in the past in relation to past assessments. But there is a post-judgment interest that is put, which is 6%, and 6% on each installment, on each delay
yeah.
of each installment. So that's also interesting. Now, quickly on experts, there's a lot to say about the way the court addressed the issue of experts in this case at a very, very late stage. I think one of the reasons why the court found it necessary to appoint experts, which is of course in its power, is that the evidence produced by the two parties was so contradictory, and that the quality of the evidence of the DRC was actually a bit deficient. So Uganda at some point was very nervous about this issue of expert appointment, thought that it was a way for the court to help the other side. Of course, that must be avoided. The court must not be seen in that way, and I don't think the court did it for that purpose. I think the court appointed expert essentially to protect itself. Showing that it did everything it could in this case, The court is critical of its own experts, of certain of its own experts in the judgment. Mike, I saw on the, hi Mike, Mike Baker, you asked on the chat whether the court should have appointed an expert on the capacity to pay. They did not. They did not appoint an expert on the macroeconomic damage, which for Uganda was a relief, and assigned that they had already made a judgment that this was nonsense from a causal point of view. And then the question of Nicoletta concerning evidentiary discount factor of 25%. I think that is quite standard practice in certain loss assessment and loss adjustments experts. But of course, whether it was taken into account by the court or not, we don't know. There are certain claims and certain heads of damage that the court says not established at all, no sufficient evidence. And then there is the rest where the court says, oh, well, there is evidence, but not clear-cut evidence, and I'm stirring a bit around, and I find a big number or a number, and you don't really know what the number covers in subheads of damages. Anyway, so
especially for the victim, the part on the personal.
Yeah. The part
one seems to feel that, you know, it's just not enough. I mean.
Not enough, and that comes to the question of Louis, the human rights. I was coming to that. You're right, Louis. I mean, this is an issue. Now, it's a human rights case without being a human rights case because it's an interstate case, and in interstate cases, maybe also jura vigilantibus applies. I mean, it is for, you know, you have to take your claim seriously, and you have to be vigilant about your claim and the way you collect your evidence, etc., etc. And the court, very often in the judgment, the court actually says to the poor DRC, you know, you did not do your job properly. I'm sorry, I cannot decide in your favor on the basis of the things you present me. Tough luck. But that's, you know, and the state, of course, it can create in the DRC a real problem of representation you know, do the public authorities of the DRC take their own people seriously by putting up a case? But I want to be generous with the DRC, because the DRC is a country very dear to my heart, and we know how the public institutions are deficient, and not only on that, and your question, Louis, goes to the balance between the public and the private interest. Fundamentally, when the private interest of the victims is taken over or represented by public authorities. And you're right. I mean, and you've seen what the court says about the expectation of the court to see the money channeled to the real victims. The court points to the undertaking of the DRC agent in court, that the money will not sit in the deep pockets of some leaders of Kinshasa. It's a real concern for the court, you know, and the question, you know, for Uganda will be, do I really have to pay on the 1st of September if the DRC has not put in place the commission and the fund under international supervision that they promised to the court they would set up? I mean, they've been saying that since 2015. They've done nothing about it. Or there is a decree, but the decree has never been implemented or something. So it's a real question. Do you want that money to go in a Swiss bank and end up in, you know, in the hands of someone in Kinshasa? And of course, it's something that the judges who read the papers had in mind, certainly. And maybe also it's a reason for being careful and prudent in the amount of money finally awarded. So that's what I had to say. Mohit, I'm sorry you were interrupted in your, the sound did not come through to me. I know you were talking about capacity to pay and evaluation, but I'm sorry I was interrupted. So that's so far. I'm not going to say more.
Thank you. I think, Nicholas, we've covered most of what has been on chat, and I don't see other raised hands. We've gone well over the hour.
I can stay.
Oh, great. Okay. So let's get our,
Shall I read the outstanding questions? Okay.
Yes, I think I wanted to react to something Arman is saying. Could you please read them and then we can.
Yeah, I've collected 4 questions and I will read them out in the order that they came in the chat. So the first question was by our colleague Tassos Gourgoulinis, and I guess it is addressed to Martin. So he asks, how does or should attribution affect the question of crippling compensation? For instance, in case of attribution of conduct carried out in the absence or default of official authorities, is there a more plausible argument for not awarding crippling compensation compared to cases involving attribution of conduct of state organs? Then there is a question by Arman Sarmarian, who says hello from the archives of the United Nations. So Arman's question is on the question of valuation, which he characterizes as a hill on which Martins is reluctant to die. So Arman says, it seems to me that the jurisprudence across the dispute settlement system is largely sporadic rather than methodical on the matter, considering, for example, the classical and modern claims commissions, reparation settlement treaties, Iran-US Claims Tribunal, European Court of Human Rights, and ISDS. Even if this was not central to the late Judge Crawford's thinking in the 90s, might this not be a more prominent reason for the broad generality of Articles 31, 34, and 36 of the Article of State Responsibility? The thought occurs that it might be interesting for the ILC to examine valuation methodology, particularly as the jurisprudence has increased. Then I have a question by our other colleague, Ms. Eleni Micha. Basically a note and a question. So the note is, yeah, I'm coming, yeah. It has to do with the payment by installments as to the practice before the European Court of Human Rights and the execution of its judgments. So until now, says Eleni, there was only one claim with regard to payment in installments, the Greek case of Stratis Andreadis, which was rejected by the Committee of Ministers. And it remains to be seen whether the committee will address the issue in the same way in interstate applications. And the question is, do you think that the lower level of proof applied in the case of Congo versus Uganda is connected and even influence the final judgment of the court? And a final question that came to me from Ms. Marina Trindade is whether the idea of substantial performance from contractual law could be applied per analogiam and logically within the idea of crippling compensation and payment in installments. I guess that Mike's question was addressed by Professor Darjan about experts and their role in such questions of compensation or reparations. That's it.
So, any comments from Martins or Pierre briefly to these? I think most of were just comments, but.
Sure. I mean, I think again, already quite late-ish in Athens, so I'll try to be brief and just to add, I suppose, as well, kind of to underline the importance of Pierre's point about good pragmatic reasons for not arguing particular points. And I think also really sort of the hard policies, what is respondent better off stretching the sum over as long a time as possible, but that might encourage the court to be more generous with the compensation. These are hard questions, and I think on crippling, when I have talked with people who have argued these cases on behalf of states, there are really many things that are raised. There may be good financial policy reasons for a state that is trying to attract investment, not to say I'm on the verge of bankruptcy. So I think that there are sort of international law does not operate isolated from other things. That is probably kind of one takeaway here. Really excellent questions. Anastasios asks about whether attribution is a relevant consideration. And legally speaking, the answer would probably be no. Analytically speaking, although I think it's interesting, and this is something that comes up in the ILC articles, it comes up in the judgment, and it's something that Pierre alluded to regarding proof, in particular regarding the Turu region, that if, primary rules are analytically separate from secondary rules, but it seems that the second part runs closest to each other, and ILC explicitly says that primary rules may play a role. And effectively, I think Judge Yusuf was in particular forceful in his opinion, criticizing the approach that the primary rules of occupation appear to reverse the burden of proof and impose a double burden on Uganda. So I think these are interesting questions. So I think instinctively the answer would be no, but at the same time appreciating that the instinctive insistence on the separateness of primary and secondary rules might not always be that catching in the world of Part 2. Arman notes about evaluation methodology and whether it might be worth having another look at that. And I think that is really the interesting point about the second part. If we look at the things that people were excited about in the 1990s, they were excited about countermeasures, they were excited about multilateralism. Very few people were excited about compensation. So if we look at the great Annuaire Français, AGIL things, probably only Dina Shelton's article in the 2002 AGIL is something that tackles that really sort of directly, and Christine Gray a bit indirectly. And there certainly have been many things that have happened in the last 20 years. So again, I think that probably falls in a bit in that provocative questions that Sotirios raised, so I'll rather leave it for another day. And I think Eleni's point about the execution of judgments is an important one, and perhaps, again, trying to fall down from the analytical purity of state responsibility to the different institutional settings through which responsibility is implemented. I think that is really spot on, that of course, bodies operate in a particular institutional setting. Bodies that have committee of ministers and department for execution of judgments will play differently from the International Court of Justice, that would play differently from ad hoc tribunals that do not really have a major investment in institutional legitimacy at all. So I think broadly speaking, I'm happy. I'm sort of on the same line with the tenor of that, and I think that was all for me. Thank you.
Thanks, Martins. And Mohit Pierre has written his question.
Yes, I see that. Thanks very much.
So it's about whether the installment, the fact that there were installments suggests that the court might have taken into consideration.
I agree with that. Yes, I think there were probably two considerations, and they are intertwined. Not necessarily crippling compensation, but also a judgment whose immediate execution would be difficult, because obviously $325 million, it's a big sum for a state like Uganda, but it's not. We are not in the range of what could be called crippling compensation, I think, and still there are installments, and I think this is tied to the idea of the court that it wants this dispute to be settled once and for all. And so it wants a judgment to be susceptible of being implemented and to sweeten the pill for Uganda that way. But yes, you're right. There might be some consideration of capacity of payment taken into account. It's interesting what you said, Martins, about the 65 million related to the 1%. Interesting. Now, I agree with you, Martins, that attribution and crippling compensation are not linked. I entirely agree with that. Attribution should not come into the picture. This being said, the secondary rules can be used to circumvent attribution. And this is exactly one of the big issues in that judgment. Because of the breaches in occupied Ituri of the positive obligations of due diligence by Uganda, the DRC was arguing in that case that despite the fact that the court found that Uganda was not responsible for the conduct in terms of attribution of the various factions and militias that were established in the DRC and that were receiving support from Uganda. Let me remind you that the court in 2005 found that Uganda was not responsible for creating those rebel groups, but that it was responsible for funding them, for providing all sorts of support. And that was in breach of non-intervention, but also in breach of specifically in Ituri, and in Ituri it applies to the rebel groups supported by Uganda, but also to other rebel groups supported by the DRC. And in Ituri, there were many rebel groups actually supported by Kinshasa, fighting on behalf of Kinshasa. But in Ituri, there was this due diligence obligation to prevent human rights violations. And now the DRC came to the court and said to the court, okay, the groups that were helped, funded by Uganda, their conduct is not attributable to Uganda. This is res judicata in the 2005 judgment. Fine. But without the help and the support of Uganda, they would not have committed their crimes. So in terms of causality, Uganda has to pay the full amount. We don't, and because of the breach of the obligation of non-intervention. And that was for the conduct of rebels all over the territory of the DRC and not only in Ituri. And that was a way to use causality to circumvent non-attribution. On that, the court does not really reason and respond, and there is very few on causality. There's one issue which relates to the rebel groups in Ituri, whether they are funded by Uganda or by Kinshasa. And on that, I argued this issue of causality, and of course I tried to draw from the Bosnia-Serbia case and the obligation, the causality in violation of a due diligence obligation to prevent certain events from happening. And you remember the test of causality applied by the court in the Bosnia case. And the court says, well, no, here it's different. And you've read the judgment, and they say it was for Uganda to disprove causality in occupied Ituri because it was an occupying power. And what does the court draw from that? We don't really know, because it has not, identified specific breaches that were the result of the conduct of specific rebel groups. So in terms of, this is a general assessment of causality, which is extremely difficult to translate into part of the judgment in terms of money. How much among all those sums comes from that reasoning? We just don't know, and we shall never know. It's interesting. I think it's a strange. I find it a little bit, because it's a bit dangerous. The UN has a mandate of protection. The MONUC has a mandate of protection in Eastern DRC. They must prevent harms from happening. Is there also for them a reversal of the onus of proof in terms of causality? Is that not an encouragement to deploy more troops abroad when you are an occupying power? Because, you know, why would you limit yourself to 10,000 troops if at the end of the day you will be responsible for everything that is happening? You might as well have 100,000 troops if you have so many. So, and the court does not really explain why this reversal of the onus of causality exists in a situation of occupation. Equitable consideration, yes, I think there were equitable consideration. The court cannot say so. Judge Iwasawa
within the law, though,
says this is not exequat bono. It's interesting that he finds necessary to say it, and it's probably the evidence that it is. And the developing country question, I think the answer is yes, it goes to the issue of capacity to pay, and the issue of capacity to pay, of course, will always be context dependent, and also in relation to the developing status of the person. What is ugly in the world of compensation is that the status of the country, the value of life is not the same in New York or in Kinshasa. And of course, the court did not want to go into those things. But if you take, you know, the average income of a Congolese person, it is $2 a day. So if you are killed when you are 35 and you live in a country where the average expectancy is 53, you see the value of your life economically? 53 minus 35 multiplied by $600 a day. That's not much, huh? $2 a day. $600 a year. Yeah, it's not. It's you know. And are you going? If you do compensation the same way a domestic judge does compensate? In my very early life as a lawyer, I worked for my tort law professor, and I did car accident, plane accidents, surgery accidents, all sorts of accidents. So, and that's also why I worked on war reparation to a certain extent. But you know, domestic judges are used to put a figure on the value of a person depending on the income of that person. The widow, blah blah blah, has certain rights, etc. We don't do that in international law, and of course. But if you say to an American citizen, your life is worth $5,000, it will be an outrage. And if you say that to a Congolese person, that might be sufficient. But this is the real ugliness of the difference in development when we talk about compensation. And that does not depend on the capacity to pay of the debtor, because the rich killing poor people abroad does not need to pay more because it has the capacity to pay. Reparation is only reparation.
And we tend to, when we think about, you know, reparation in the context of state responsibility, Martins and Pierre, you know, general state responsibility. I mean, sometimes we overlook what is happening in parallel in human rights adjudication or in other fields. And there was a question there about, you know, from Nicoletta again, about the developing countries. You know, in the 60s, this idea went in both covenants of the International Covenant on Civil and Political Rights in the first article, and I think also in the Covenant on Social Economic Rights, about the use by states of their resources without, based on the principle that people may not be deprived of its substance.
Means
So
of
happened
subsistence.
So that happened in a context of human rights. It happened in the 60s. I'm not sure it was fully fleshed out in the 90s and 2000, when the ILC was looking at state responsibility.
It was maybe at the time a little bit the mirroring image of the sovereignty of states on their natural resources.
Absolutely.
There were those two. I mean, that was a big issue, of course, at that time, and maybe the human rights mirroring point was the obligation not to deprive people of its means of subsistence. But I don't know enough about the drafting of the governance on that point to know if
that was it, and it also had to do at that time with the idea of investments.
Yeah.
And with the declaration on the developing countries. I don't remember which one. So it came it came differently, but it had to do with how states would have be able to determine their own resources because of what was starting to happen, among others, in investment. But of course, at that time, we were not talking about sums that we talk about today in investment arbitration. And Louis, I think, shares my sort of pessimism when we look at the huge sums of investment arbitration. That's where I think crippling compensation came from. And then when you look at the more modest sums, when, as Pierre says, when you try to quantify a human life or human lives or mass violations of human rights and international humanitarian law. So I think this is a discussion that will continue, but we have to stop, even though in Greece, we, as you know, are late. We live late in the evening, but I think we've tired most of our audience who do not have our traditions. And I would like to say that there's a lot of questions, and Dr. Paparinskis has kindly allowed, and I think through Nicolas, if any students want to ask him questions, they can send mail, and perhaps Pierre d'Argent would not be, would also accept receiving emails.
Of course.
Most of the students here, I hope, are members of the European Society of International Law, Mr. President. I hope.
I'm not responding a question if it is not sent by a member.
Okay, so I hope that this will induce everyone who is not to become. But I want to thank you both very much. Martin, thank you very much. Professor Pierre d'Argent, thank you very much. This was an excellent discussion.
Thank you so much, Faye, and thank you, Martin.
It's opening, I think, not closing a debate. It's really opening it, and we'll probably have more to say.
Thank you. Is there a place for a day-long conference in Athens in spring, perhaps?
2 days, 3 days, a retreat, anything you want.
I second you on the spring in Athens, or the Athens in the spring. Okay. Oh, you're mute, Faye. You're on mute.
The members here will take note of that and then plan accordingly. Let me thank all of you, not only our speakers, but also all of you who participated in this very interesting debate. See you soon for our next installment. You'll be advised when it comes up. But it was very good to have both our very distinguished guests and also to see many friends on this screen.